Afternoon, ladies and gentlemen. My name is Stephen Madani. I'm a member for Group 13 Commercial Law, University of Zimbabwe. Our group is Group 13, and the members are Festo Madembo, Stephen Madani, Zedia Simdariki, Edmo, Eddie Nyamugunduru, Blessing Chamboko, Richard Chiesa, Vincent Gapara, Tryphine Sibanda, Natalie Shasha, and Rachel Kasu. Our presentation is going to be on the TRIPS, which is the trade related aspects for intellectual property rights. Mr. Chiesa is going to take us through the PowerPoint presentation. Thank you.
Okay. Good afternoon, colleagues, and welcome. As introduced, we are Group 13. My name is Richard Chiesa, representing here the commercial law class. We're doing on presentation on intellectual property, and I will go through an overview, a historical overview of intellectual property rights, and then come into the TRIPS agreement, as already introduced, the TRIPS agreement, which basically forms the basis of the international legal system governing intellectual property. Intellectual property rights are basically territorial and anchored on the principle of national treatment. That means countries are expected to treat other countries, authors and inventors the same way they treat their own citizens when it comes to the legal protection of intellectual rights. They are created by national law and apply to conduct within that jurisdiction. The legal system at international level is put in place to protect the rights of authors, inventors, and other creative works. The first one was basically the Berne Agreement of 1886. The Berne Convention deals with the protection of works and rights of authors. It is based on three principles and contains a series of provisions determining the minimum protection to be granted, as well as special provisions available to developing countries that want to make use of them. The convention has three basic principles: works originating on the contracting states, that is, works by an author who is a national of a state, or works first produced or published in such a state, must have been given the same protection in each of the other contracting states as the latter grants to the works of its own nationals. The principle of national treatment, as we have already spoken to. B, protection must not be conditional upon compliance with any formality or principle automatic protection. C, protection is independent of the existence of protection in the country of origin of the work, the principle of independence of protection. If, however, a contracting state provides for a longer term of protection than the minimum prescribed by the convention and the work ceases to be protected in the country of origin, protection may be denied once protection in the country of origin ceases. However, there were problems with the Berne Convention because it lacked an enforcement mechanism. But its major premise, which I've already gone through, like the three basic principles, formed the basis of the TRIPS agreement is established in 1995. The agreement on trade-related aspects of intellectual property rights, that's the TRIPS, is an international legal agreement between all the member nations of the World Trade Organization. The inclusion of intellectual property rules in the international trading system was a watershed event, or probably brought a new era in the creation of legal infrastructure around the protection of the rights of creative works. The inclusion of it was negotiated during the Uruguay round. The 1994 agreement on trade-related aspects of intellectual property rights, or TRIPS, significantly broadened the reach of the trading regime. The aim was to boost economic recovery post the Second World War. IP rights and the emergence of TRIPS. According to the World Intellectual Property Organization, or WIPO, intellectual property includes rights relating to literary, artistic, scientific works, discovery throughout all areas of human endeavor, the scientific advances industrial designs, rights, trademarks, service marks, and commercial names and designation protection against unfair competition. The WTO's TRIPS agreement recognizes the importance of IP in international trade. TRIPS represents agreed trade standards for the IP rights, considered as a method to bring greater order and predictability in the market. It is viewed as a more systematic approach to the resolution of disputes over creative works. The TRIPS agreement protects intellectual property in trade-related regions. It is a comprehensive new framework for intellectual property standards protection, and has the distinction of being the first legal agreement to address all areas of intellectual property. The agreement governs three main areas. One, standard. All member states are required to provide the minimum state criteria of the protection of IPRs in each of the IP category covered by the agreement. Two, enforcement or intellectual property rights. The agreement established a set of broad rules that apply to all IPR enforcement actions, including procedures, rules, or civil and administrative processes and remedies that allow rights holders to successfully exercise their rights. And this one specifically is where the TRIPS agreement differs from the Bain agreement that we spoke about earlier. The third one is the dispute settlement mechanism. There are obviously going to arise legal disputes around the ownership of certain rights or patents, or is it copyrights. So there is a dispute settlement mechanism is provided for by the WTO. We know that the WTO is basically a broad dispute settlement mechanism dealing with major issues around the trade among nations in the world. So it provides a specific dispute settlement mechanism for intellectual property rights. Disputes occurring between WTO members over responsibility emanating from the TRIPS agreement are subject to the WTO's dispute resolution processes. The whole TRIPS agreement is further divided into 7 parts, which contain the complex provisions regarding intellectual property. And we thought we can briefly just run through them. Part 1, general provisions and basic principles, that's Article 1 to Article 8. Part 2, the part covers the requirement for the availability, scope, and application of intellectual property rights, Article 9 to Article 40. The part 3 is enforcement of IPRs provided for in Article 41 to 61. Article 4, the part covers the procedures for obtaining and maintaining intellectual property rights. That's Article 62. Part 5 deals with the prevention and resolution of conflicts arising from the provision of the agreement. That's Article 63 to 64. Part 6, transitional agreement. This basically says states are divided into various categories related to their level of development. So all these categories are then given a time frame to transit from where they are to where they are expected to be under the TRIPS agreement. So if you say you are in a developing country, you can't be in the same category with a developing country. If you have an economic structure post 1995 or 1994, when the TRIPS agreement was established, if you had a command kind of economic structure, you were allowed to, in your liberalization processes, you were allowed a time frame to then easily ease yourself into the TRIPS agreement as part of the WTO membership. In part 7, this part of the agreement deals with a variety of institutional arrangements, how the TRIPS Council and probably Secretariat and other arms that regulate the intellectual property is set up. So we will then move on to look at types of intellectual property rights. The first one is copyright and its related rights. Copyright protection applies to phrases, ideas, techniques, operating methods, mathematical concepts, literary, musical, dramatic, photographic, sculptural, architectural, choreography, graphic, motion, picture, sound recording, multimedia work, computer programs, and other works, all are given copyright legal status. A jurisdiction then provides for a timeline within which these are protected. In Zimbabwe, the Copyright and Neighboring Rights Act, Chapter 26.05, provides that most works are protected for, that's copyright works, are protected for 50 years. So you've got a 50-year period to stop anyone from taking your work, Kanarima, if it's Macheso and his works, he has 50 years from the release of his album to when it can be used by somebody else. This is in line basically with the TRIPS Agreement's Article 12, which provides also that copyright works are protected for 50 years. So Zimbabwe basically copy and pasted the TRIPS Agreement. Then we move on to trademarks. Article 15 of the TRIPS Agreement provides that any sign or set of signs distinguishing one's undertaking products and services from other undertakings shall be eligible for trademark registration, provided that it is clearly detectable. Such signs, in particular words, character digits, figurative components, and color combinations, as well as a combination of these signs, and must be acceptable for trademark registration. According to Article 16 of the TRIPS Agreement, the trademark owner has the exclusive right to restrict third parties from using similar or identical signs for products and services that are similar to those for which the trademark is registered. So we have a case that we thought we might share with colleagues on this one: the Vivon Investment Private Limited versus Winking Investment Limited. This is to do with distilled water that is sold in shops. The applicant, well, that is Vivon Investment, approached the court seeking an interdict, an interim interdict in terms of Section 9(2) of the Trademarks Act, Chapter 26.04. The court held that the test to whether there has been infringement depends infringement of a trademark. It depends essentially on whether there is sufficient similarity which is likely to lead to confusion. There is no doubt that the offending mark, that's according to the document, offending mark being used by the respondent, Winking Investment, bears a marked resemblance and likeness with the applicant's trademark. These products are sold in supermarkets and close to each other. It is reasonable for the applicant to apprehend injury in the form of loss of business. The court granted the provisional order as prayed for. Colleagues will remember that there is an unreported case recently of INSCO Limited against Chicken Slice relating to Love That Chicken and Love This or something like that. This case has not been reported yet, but basically it had to do with similar trademarks in relation to the packaging around fast foods that are sold by the two fast food chains, Chicken Inn and Chicken Slice. Chicken Inn owned by INSCO. So the court ruled that there was nothing very similar because the Chicken Slice packaging relates to burgers, not necessarily to chicken cutlets as used by Chicken Inn. So basically, this case was thrown out and Chicken Inn lost the case because they had not registered the trademark anyway. It is just something that they thought, because they've been using for a long time, it had become part and parcel of their infrastructure in terms of the trade in the market. The other type of intellectual property is geographical indication. These are IP rights that identify a product's area of geographical origin, its quality, reputation, and characteristics that are essentially attributable to its specific area of origin. Article 22 provides for a legal protection of the purpose and value of geographical indication. It further says that unless a geographical indication is protected in its country of origin, there is no obligation under the agreement for other states to extend reciprocal protection. I'm not sure, but we think maybe the Mazoe brand, because it is associated with Zimbabwe, but you colleagues will know now it is produced in Zambia, maybe because of issues of labor and the cost of doing business. It is produced, but it is associated with Zimbabwe. Its characteristics and nature is basically associated with Zimbabwe. We're not sure whether Schweppes is registered this is a geographical indication or otherwise. Maybe because now that it is produced in Zambia, it shows that it may not be registered. So Zambia has no obligation not to produce it as it was. According to the African Regional Intellectual Property Organization, ARIPO, which is basically headquartered in Zimbabwe, there are two approaches to the protection of geographical names. Public law approach, the public law approach which public authorities enact legislation dedicated to specific protection of geographical indication, also known as sui generis law. And the private law approach, which allows for use of laws against unfair competition, passing off or trademark law, collective or certification trademark. Zimbabwe enacted the Geographical Indication Act, Chapter 26.06, thereby establishing a specific legal and institutional framework for the protection of GIs. Industrial designs are another type of intellectual property. Article 25 and 26 of the agreement gives obligation to member states to ensure that fresh or unique industrial designs generated independently are protected. Based on the Paris Convention, this part of the TRIPS agreement provides for the preservation of industrial designs for a minimum of 10 years. Right holders can legally stop third parties from producing, importing, or selling items that incorporate a protected design without authority. We have a case on this one again. Industrial TCU Limited and Reader International Industry U Limited civil suit 0359 of 2019. This is a Ugandan case. Plaintiff Migu had sued defendant Reader for infringement of his industrial design. The background to the case is that in 2012, Migu contracted Mr. Lee Dong Biao to design in an industrial mode for the production of gumboots. However, in 2016, Mr. Lee incorporated Reader, which also manufactured sold gumboots, Reader's gumboots, and sold gumboots. So basically, he started a company to do the same work that he had been contracted to do under Migu, the company Migu. Reader's gumboots were identical to those produced by Migu in design, shape, size, color, and size. Reader registered industrial design in 2018. You see, before Migu registered in 2019. So the guy who was stealing the idea registered the industrial design earlier than those who had started it actually. However, Migu had began the production and sale of the gumboots, the distinctive design in 2012. That's probably 6 years earlier. So the High Court of Uganda's decision on the infringement of design rights was a first. In determining whether a design is identical or similar to the registered design, the court must make a visual comparison of the two products. Court noted that it would find an infringement of the exemplars such as to deceive such an observer, inducing him or her to purchase one. Supposing it should be the other, right? In determining the similarity between the two products, the court considered, among other things, the nature of the good to which the industrial design was applied, the intended purpose of the goods, the method of use of the goods, the complementarity of the goods, whether the goods were in competition with each other in the maybe distribution channels and stuff like that. So they ruled in favor of the applicants in this case, and those that wanted to steal the idea lost it. The other IPR right is patents. According to Article 27 of the TRIPS Agreement, a patent is an intellectual property right awarded to inventors. The inventor of the patent is the patent owner has the right to prevent anybody else from creating, using, selling, or importing the patent protected invention in a specific region for a set length of time. Patentability is subject to 3 criteria or exceptions. Innovations that are centrally or harmful to public good or morals, harmful to human, animal, plant life, or health, or that are substantially harmful to the environment are not allowed. Members may also include diagnostic, medicinal, and surgical procedures for the treatment of people and from patentability. The length of protection is normally 20 years. That's for patents from the date of filing to the patent application. Member nations could provide specific exemption to exclusive rights conferred by a patent under Article 21 of the agreement, if such exclusions do not unreasonably conflict with a normal exploitation of the patent. Furthermore, Article 29 mandates that the patent filing discloses the innovation in a manner that is explicitly clear and complete for a person knowledgeable in the art of to carry out the invention. Article 31 of the agreement contains provisions that allow the government of a member nation to award a compulsory license for medicine without the patentee's approval, subject to specific circumstances. The trustee, there is a case, the trustee of Mukono Family Trustee and another versus Carpeg Investment and others. A local electronics engineer, Mukono, brought an infringement of patent case against several hardware outlets. Mukono, through his company Mukono Electronics and Mukono Family Trust, initially sought to buy 7 electro engineering firms from producing versions of sage protectors he invented. He demanded 50% of all profits made by the firms from the counterfeits since 2009. He, however, withdrew his claims against 6 of the companies except for Capec Investment, which trades as Kada and Sons. The High Court ruled against the plaintiff on the basis that the registration of the design was a nullity and conferred no rights on plaintiffs against any alleged infringement of the alleged rights by the defendant. Other types are layout designs, which is typographies, trade secrets, trade secrets rather. But there are also transitional provisions. We have spoken about transitional provisions where states, given their geographical and economic status, are given under the TRIPS agreement space or timelines to confine or conform to the new legal order or legal system around the TRIPS. We have also tried to look at contemporary issues affecting or that are affected by IP rights and the TRIPS agreement. The Doha Declaration on the TRIPS agreement and public health of 2001, which affirms that the TRIPS agreement should be interpreted and implemented so as to protect public health and promote access to medicine for all, demonstrating that a rules-based system should be compatible with public health interests. Article 31F of the TRIPS agreement stipulates that a compulsory license must be issued predominantly for the supply of domestic market for the member granting the license. Consequently, many countries without a significant pharmaceutical sector have not been able to take advantage of the compulsory licensing provisions of TRIPS. A key problem that has emerged under TRIPS was that member states are allowed to issue compulsory licenses for importation. There are restrictions on the importation of goods from countries where pharmaceuticals are not patented or where the term of protection is expired. Paragraph 6 of the Doha Declaration instructs the Council for the TRIPS to find an expeditious solution to the problem in making effective use of the compulsory licensing provision. In 2002, the WHO, the World Health Organization, publicly committed to support WHO members in the TRIPS Council in resolving this problem. The Doha Declaration recognized the gravity of the public health problems affecting many developing and least developed countries, especially those resulting from HIV and AIDS, tuberculosis, malaria, and other pandemics like the COVID-19 pandemic from 2019. But the declaration reflects the concern of developing countries and the least developed countries about the implication of the TRIPS agreement with regard to public health in general without limitation to certain clauses. The declaration clarifies that public health crisis can present a national emergency and other circumstances of extreme urgency, and that an emergency may be either a short-term or long-term, and we have seen this with the COVID pandemic, where access to production of medicine has been key to access to vaccines. Western countries that have access to production and scientific knowledge and information around the production of vaccines that treat the COVID-19 virus have shown that up to 90% of their people have access to the second dose or even the third dose as it were. But African countries that have been restricted to the first dose only because they don't have pharmaceutical production of this of the virus injection that protects people against the COVID pandemic, and because producers of these vaccines and funded by millionaires or multi-billionaires like Bill Gates have refused to release information around this. It is shown the weaknesses around the Doha Declaration and the TRIPS agreement itself, that while the World Trade Organization have power to enforce some of its provisions, it cannot force these people with money across the world, especially in the Western world. We have money to produce and protect their scientific knowledge and patents around the vaccine. So this is what is happening at the moment in the politics around vaccines, around medicines, and around intellectual property. But in Africa, you'll find the ARIPO, that the African Regional Intellectual Property Organization that we spoke about, is sought to bring together African countries to create a legal infrastructure that speaks to current issues or that speaks to the needs or requirements of African countries across the world in trading in intellectual property. This is where we end it. Thank you very much for listening and watching. this is under the treaty.